Hi, my name is Brad Lohner, and I'm the owner of Priority Credit Recovery in Edmonton, Canada. And I'm pleased to present the various aspects of debt collection in Canada from my colleagues at the League International for Creditors. I'm going to present a PowerPoint presentation here for you to give you a better understanding of who Priority Credit Recovery is and what we can do for you. So a little bit about Priority Credit and Brad Lohner. Where is Edmonton? On the red map you can see where we are, and the little star is where I'm at. It's a big country, and we're right in the middle of oil country. I started in the collection business in Canada in 1985 as a junior collector. I just answered an ad in the newspaper and got affiliated with a national consumer-based agency. 5 years later, I became a partner in the firm, and we grew it from just a small group to over 280 staff in 2005. In 2005, I resigned my position and began Priority Credit Recovery because I noticed that there was a big gap in the Canadian commercial collection market space. I co-authored a book with David Franklin, who's a well-respected attorney here in Canada, and it covers all the different aspects of what a collection agency does in the Canadian market space. I thought I would provide you with some information with respect to credit applications and credit agreements for your customers. So this is something you can take back to your client and give them some information. If they're going to be selling to Canadians in any way, this is a credit agreement that they can use that will help to not only hold the business liable, but also the business principal. And so I'm not going to bore you by reading through this point by point, but suffice to say that if you give this account agreement to your client and encourage them to use it, they're definitely going to come out ahead. On the second page of this slide, we see point number 8. It says we business principal's name here. This is a indemnity clause that will, if it's filled out correctly, will hold the business principal of the credit applicant liable. Now, we want to do this because if the corporate customer disappears or goes out of business, we can still go after the business principal for the debt and try to collect from him. I should note, however, the province of Alberta, where I'm at, has got this bizarre law. We cannot have a personal guarantee signed by a notary. It's got to be in front of a lawyer now. So if you obtain a personal guarantee from a corporate customer in Canada, that personal guarantee has got to be signed in front of a lawyer, giving that individual professional legal advice to advise him or her what her liability is going to be before they sign that credit application. So just be aware of that. If the business owner signs this agreement, the original creditor and its Canadian agents can obtain the owner's personal credit history as well as business credit history. So making decisions for us with respect to recovery, much easier. Some other important tips to remember about Canada is that our Canadian courts recognize emails as admissible evidence. So tell your customers to maintain all their PST files, Outlook PST files, print copies of it out, send those to us, different things, because those credit applications, or those emails rather, are critical in establishing if the person's admitted liability and those types of things. And also, if the Canadian corporate debtor tells you they're having cash flow problems, act right away. I can't tell you the number of times over the last year and a half where Canadian companies, because we're a resource-based economy, get themselves in cash flow problems. The creditors are very sales-oriented. They want to try to work with that customer to keep them and try and do a workout, that kind of thing. All very admirable suggestions. However, if the corporate customer is exhibiting a lot of really early warning signs, and we'll get into that a bit in our presentation, you're going to want to send that claim out to collections to a third party or to your attorney right away, because if there's smoke, there's going to be fire. Geographically, Canada is a very large country with a very small population. We only have 35 million people. Distances between major cities are making it almost impossible to do site visits. I know some agencies like us to do site visits, or at least attempt to. However, it does take about 9 hours to fly across the country from coast to coast, so just to give you an appreciation of the geography. Also, something to consider, if the debtor has not provided written consent in the credit application or the credit agreement, the Canadian agency cannot obtain financial information. So the credit applications or the signed customers' applications are super important because that gives us information that we can work with. I thought I would provide the top 12 danger signals. Now, these are signals that the Credit Institute of Canada has put together over the course of the last 50 years. I didn't write this. This comes from credit managers in Canada who tell us what the top 12 danger signals are that creditors should listen for. I thought I'd provide this slide to you because I'd like you to share this with your clients. Not only will it be helpful for them in their work, both domestically but also foreign. So if they've got a slow payers in Canada, these are the top 12 things that they should listen for. And like I said before, if they hear any of these different reasons for non-payment or suspect rather something is happening, make sure that this claim is sent out to either a qualified agent or a law firm right away. I thought I'd touch on Canadian commercial and consumer credit bureaus. This is something that's sort of misunderstood in Canada a little bit, so I thought I'd touch on this for everybody's benefit. There are 7 credit bureaus in Canada. Equifax and TransUnion are the 2 bureaus which maintain consumer data. Both of these bureaus also maintain commercial data. The other 5 regional bureaus include Mercantile Commercial Credit, which is known as Lumberman's, Credifax, D&B Canada, or Dun & Bradstreet Canada, Sterling West Credit, and Group Echo, all which are very, very good commercial and consumer credit bureaus. Also, I thought I'd touch on obtaining public record information in Canada. Public information includes access to land title information, so we can find out does the business or the indemnitor, do they own real estate? Do they own real property? Second is called the personal properties registries, which are the debtor's assets held as security by a lender. So if legal action becomes necessary, do you not want to seize that Caterpillar because it may be financed by the bank? And thirdly is the company registry. Is the company valid? Who are the directors? Some provinces still maintain control of this data and others have privatized, like Alberta has. Priority Credit Recovery maintains national search capabilities in all of its databases, and this information is super helpful for us when we decide to take a matter to court. I thought I'd touch on the Canadian Consumer Protection Act, the differences between provinces and how it can negatively impact your ability to recover money. When a LIC member retains a Canadian collection agency, that agency may not be able to legally do the work and open up the LIC member and its customer to reputational liability. In Canada, there are various consumer protection acts known as, or provincial legislation, that govern how money can be collected, how much interest can be charged, and how negative credit is reported. Canadian agencies must be licensed and bonded in the area where the debtor resides, and there are strict fines levied for non-compliance for this, so make sure you partner with an agency that's licensed. And lastly, provincial legislation prevents collection agencies from being able to charge collection fees to the consumer debtor, even if it's agreed to in the credit application. However, this does not apply to commercial transactions. We've saw a few claims come through from both American and European agencies where we've been asked to charge the fee, or the fee has already been added into the debt. If it's a consumer claim, it's against the law. If it is a commercial claim, it's definitely within the law to charge it and to attempt to collect it. However, recovery of those collection fees can be difficult. Next is the Provincial Statute of Limitations Acts and how it applies to your ability to use the Canadian court system. Recently, 3 of Canada's provinces have enacted 2-year limitations on the time period with which a creditor may take a debtor to court. So the 3 jurisdictions are Ontario, Alberta, and British Columbia. Those are the 3 provinces in the country that have said that 2 years is the time frame. So when you're considering legal action in these 3 provinces, the action must be commenced within 2 years of the date of last invoice or date of last payment. If the legal action is commenced after these periods, the debtor company may use the Limitations Act as a defense. All other provinces and territories remain at 6 years so far. However, everybody else is looking at these 2, and that may change very soon. I thought I'd touch on how Priority Credit Recovery works your case. So I apologize for the small font here, but I'm happy to email this presentation to anybody who wishes to see it. Just my contact details are at the end of the slide presentation. Feel free to reach out and I'll be happy to provide it to you. So the first thing we do is review all the documentation for terms and conditions in the credit application. Again, information is power, and we use that. We obtain credit reports on all legally responsible debtors to determine if the credit quality of those people or those companies. We perform internet searches for news articles and related information just to find out if the company is actively conducting business and if they're being operated as a going concern. And if they are they actively seeking customers? Are they advertising? Does their website offer the goods for sale that were purchased from the original creditor? We don't know. Something we look at. Then the collector makes the first phone call and speaks directly with the person who is authorized to pay the debt and stays in regular contact with that individual. Collectors make detailed notes during the conversation as information obtained is useful later in negotiations. All this information, by the way, is available on our website. So if you become a Priority Credit client, we'll give you a user code and password to our system. You can log in, have a look, you can see the notes, you can see all the information, you can see the reports, all the scanned documents, everything. And then a deadline is given to the debtor in which they must pay. So we ask them for either payment, provide proof of damages, etc. So if there's a qualified dispute, we need to know about it. Regular reports are provided to our foreign agents, and if the debt remains unpaid after 61 days, then Priority Credit reports all these cases to the credit bureaus, which have a significant negative impact on the debtor's business. That is voluntary, it's not mandatory. So if your customers do not want you to report these to Canadian credit bureaus, please let us know in advance. However, we strongly suggest you allow us to do that because it is a collection tool. And finally, should the debtor continue to ignore demands for payment, Priority Credit begins a thorough asset investigation to figure out if legal action is really warranted. Does your client want to spend more money to chase this, or do we want to write it off? Well, that's it from Canada this time. I'm sorry I couldn't be with you there this year as I'm traveling in China in business. If you have any questions, please reach out to me through our contact details on the LIC website, either phone or email, and I'd be happy to give you a hand. And I look forward to meeting you all next time.